judge. And I'm going to talk about one final nominee that isn't before us today, but that will be soon, which is Charnel Beckelgren. Now, the members of this committee are aware of just how wildly unqualified this nominee was. She's been nominated to be a federal district judge, and our colleague, Senator Kennedy, whose cross-examinations on this committee have now become legendary, he asked her what Article 5 of the Constitution was. And she responded saying, well, she couldn't remember, she wasn't familiar with that. He then asked her what Article 2 of the Constitution was. And she said, well, that's not coming to mind either. It was a stunning display of her lack of qualifications to be a federal judge. Now, to be clear, asking someone what Article 2 of the Constitution is not some obscure legal gotcha. There are questions you can ask about bizarre, hidden legal theories that would be a gotcha, that wouldn't be fair. Not knowing what Article 2 of the Constitution is, which is what establishes the president and the executive branch, any first-year law student who didn't know what Article 2 of the Constitution was would flunk con law. And I will say Chairman Durbin subsequently said publicly she was likely to get confirmed. And he went on to say that he thought there were members of this committee who couldn't answer the question Senator Kennedy asked as well. I hope and pray that's not the case. I'm going to ask, I'm confident that on the Republican side of the aisle, the members of this committee know what Article 2 is. Are there any members of this committee who care to volunteer on the Democrat side of the aisle that you don't know what Article 2 is? If you didn't, you or I or anyone who didn't know what Article 2 was would not be qualified to serve on this committee. And I will say, I want to encourage the Democrats on the committee to follow Chairman Durbin's lead. Chairman Durbin, during the Trump administration, explained on a nominee, he said, he invoked what he called the Senator John Kennedy test. And Chairman Durbin said, quote, I think it's a legitimate test to be applied to all those who want to be trial judges, and I hope others on both sides of the table will join me in saying it's not enough to aspire. You have to bring to this aspiration some practical experience and knowledge that suggests you can meet the standard required.
Best. Thank you, Senator Booker. Senator Kennedy.
Thank you, Mr. Chairman, and congratulations to all of you. Judge on the far end, tell me what Article 5 of the Constitution does.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
Neither is Article 2.
Okay. Do you know what purposivism is?
In my 12 years as an assistant attorney general and my 9 years serving as a judge, I was not faced with that precise question. We are the highest trial court in Washington state, so I'm frequently faced with issues that I'm not familiar with, and I thoroughly review the law, research, and apply the law to the facts presented to me.
Well, you're going to be faced with it if you're confirmed. I can assure you of that.
During a tense exchange at a Senate hearing, a senator sharply questioned a federal district court judge about her overall productivity on the bench. The senator claimed the judge appeared to be among the least productive members of her district court, pointing to case output and workload comparisons. The judge responded cautiously, saying she had never evaluated her performance in those terms. As the questioning continued, the senator attempted to define what he meant by least productive, suggesting that publicly available court data showed her case numbers were significantly lower than some of her colleagues. The exchange highlights growing scrutiny from lawmakers over judicial performance, particularly as courts face backlogs and increasing caseloads nationwide. Supporters argue that productivity statistics don't always reflect the complexity of cases a judge handles, while critics say transparency and accountability are essential. The hearing underscores how confirmation proceedings are increasingly focused not just on legal philosophy, but also on measurable performance metrics.